हेलो एंड वेलकम टू सिविल सर्विस एक्सप्रेस। आज का हमारा टॉपिक है द चाइल्ड एंड एडolescent लेबर प्रोहिबिशन एंड रेगुलेशन एक्ट 1986। दिस एक्ट वाज enacted on 23rd of December 1986 with the purpose to prohibit employment of children in any kind of occupation and also to prohibit the employment of adolescent in hazardous occupation and processes and all the matters related to child labor and adolescent labor. We'll start with the part 1, which is preliminary. The section 1, short title, extent and commencement. This act is applicable to whole of India and the all territories of India. Next section is definition section. This is one of the most important section of this particular act. We'll talk about the appropriate government. Appropriate government means for a particular establishment or a kind of establishment, which government is responsible to frame rules and regulation for that particular sector or industry. In case of establishment which is under the control of central government or railway establishment, any port or any mine or oil field, central government is the appropriate government. In all the other cases, state government is appropriate government. Next definition is who will be called an adolescent. Any individual who is between the age of 14 years and 18 years will be called an adolescent. That means he have completed the age of 14 years and up to the age of 18 years he will be considered as an adolescent under this act. And who will be considered as a child? Any individual who has not completed the age of 14 years or any such age as specified by Right to Education Act 2009, whichever is higher. Currently, the 14 is the age decided by Right to Education Act 2009. So, any individual less than 14 years of age is considered as a child. What will be considered as a day in this act? 24 years beginning at midnight. That is, after 12 a.m., the day will start up to the next 24 hours. Establishment means any shop, commercial setup, workshop, farm, hotel, restaurants, theater, or any place of public amusement is considered as an establishment. This establishment definition is important to identify where the individual or child or adolescent is working. Family means definition of family includes the individual, his or her spouse, their children, and brother or sister. So this whole will considered as a family of the child. Occupier means person having the ultimate control over an establishment or workshop. That means if we are talking about the establishment or any work area, whoever have the ultimate control over that region, that particular workplace will be called as occupier. What is the definition of a week? 7 days beginning at midnight Saturday. So generally it is the days starting from Sunday is called a week, but in some other cases they can also be some other day considered as the starting day of the week. For instance, in some areas Sunday is the holiday, but in some cases Wednesday or Friday, depending on the area or the rituals or culture, the other day can also be decided by the inspector. What is definition of workshop? Workshop means any premises where industrial processes are going on. But it does not include the premises governed by Section 67 of Factories Act 1948. So, in this section, the definition of adolescent, definition of child, definition of family is important from exam perspective. Next is part 2, prohibition of employment of children and adolescent. Means what are the areas, what are the establishment where the prohibition of children and adolescent is prohibited. First is section 3, prohibition of employment of children. So any individual, any child, that is any individual below the age of 14 years shall not be employed or permitted to work in any occupation or processes. So the general rule is they should not be allowed to work in any establishment at all. But there are some exceptions too. For example, if a child is working for his family enterprise or is trying to help his family in their enterprise in occupation which are not hazardous as mentioned in the schedule given in this act, and they are doing it after their school hours or during their vacation, then they are allowed to work. Means if they are helping any family or any family enterprise after their school hours or during vacation with the idea that particular enterprise is not an hazardous occupation, then they are allowed to work in that enterprise. Secondly, if they are working as an artist in any audiovisual entertainment, ads, films, TVs, serials, or sports activities, but not a circus, then they are also allowed to work. We have seen individuals who are working in the TV industry, but they are kids below the age of 14 years. They are allowed to work under this act because they are working in an audiovisual entertainment industry, but they are not allowed to work in a circus. This is important from exam perspective. But there are certain conditions also. Any kind of work, whether it's in family, whether it is as an artist, should not impact the child's education, and there should be proper safety measures in should be done in the establishment. In this case, family means parents, means if the family enterprise is run by parents or brother, sisters, father and mother's siblings. That means parents of the individual child, brother and sister of the child, or brother and sisters of father or mother. Then the child is allowed to work in their enterprise or their establishment. Family enterprise means any work, any business carried out by the family members. Means we are talking about these family members. If they are carrying out any work, then the child can work in that establishment also. Artist means any child engages as an actor, singer, sports person, trainee in entertainment or sports as a hobby or profession. He can also work for hobby. So there might be case he is learning something for hobby, or he can also work as a professional. So general rule is they are not allowed to work in any establishment, but they can work in family or family enterprises, or they can work as an artist, but not in a circus. Next is section 3, prohibition of employment of adolescent. No adolescent is allowed to work in hazardous or hazardous occupation or processes listed in the schedule. But they are allowed to work in certain non-hazardous work. If something is endangering their life, then they are not allowed to work, but it is not dangerous, then they can work. Next is section 4, power to amend the schedule. Central government can amend the schedule. Schedule is a list of occupations that are hazardous for this act. Then the central government has the power to add or omit any hazardous occupation or processes from that particular schedule, but central government has to give a 3-month notice before doing such an act. Next is section 5, technical advisory committee. So there is a child labor technically advisory committee which is formed by central government for the purpose of advising the government on adding occupation or processes to the list of those prohibited for child labor. Means this particular technical advisory committee advise the government to add or omit particular occupation or processes from the schedule as mentioned in this act. What is the composition of this particular committee? There should be a chairperson who is appointed by the central government, and up to 10 members are also appointed by the central government to run this particular committee. And this committee can also create some subcommittees and also hire members from outside to ensure that the work is done in the most effective manner. What are the rules and regulation of chairman members, how subcommittee members are going to be work or going to be appointed is defined by central government through different rules. Next is part 3, regulation of condition of work of adolescent. So now we have seen what areas are where, what are the areas where child labor, what are the areas where adolescent are prohibited from employment. Now we are going to see how the work condition of adolescents will be regulated in non-hazardous work processes where they are allowed to work. First, section 6, application of the part. This particular part of this act, part 3, is applied. This applies to establishment where non-hazardous work is being performed or where the hazardous work is not being performed as referred to in section 3A. Next is section 7, hours and period of work. So for adolescent also, there are certain prescribed period of work for which they are allowed to work in that particular non-hazardous establishment. What are the conditions? Maximum. So the work should be divided into parts, and single part should not exceed 3 hours of continuous work. So the idea is the adolescent should not be allowed to work continuously for more than 3 hours, and after 3 hours they should be given a 1 hour rest. And the total spread, including the rest, waiting time, working hours, should not be more than 6 hours per day. That means they are maximum allowed to work for 6 hours, and for continuously they can work for 3 hours, after which they should be allowed to rest for at least 1 hour. They should not be allowed to work between 7 p.m. and 8 a.m. Means after 7 p.m. until 8 a.m. of the next day, they should not be employed in any industry. They should not be allowed to do any overtime work because they are only allowed to work maximum 6 hours per day. They cannot also work in more than one establishment. Means they can work only in one establishment per day. Next is section 8, weekly holidays. Adolescent should get one holiday per week. That's a must for every adolescent who is working in any non-hazardous establishment. What the day is going to be should be decided by occupier and in a permanent notice which is strict or which is displayed at a conspicuous place or a proper place which is visible to all the workers, especially adolescent. And the occupier can also change the day on which there will be holiday in every 3 months. Next is section 9, notice to the inspector. If there is any adolescent working in any establishment, then the establishment or the occupier should notify the inspector. In case of existing employment, assume before this act was commented in 1986, adolescents were already working in that particular establishment, then the occupier should provide notice within the 30 days of commencement of this act to the inspector with the name and location of establishment, manager's name, communication address, and the name of occupation and processes in which the adolescent is working. If the employment is new, so whenever the adolescent is employed in that particular employment or establishment, then within 30 days of employment, the occupier should notify the inspector regarding his appointment. The section 7, 8, and 9 do not apply to work is when the work is carried on with family only. So assume the adolescent is working in any family establishment. So he is not allowed, so he doesn't have any restrictions regarding hours and period of work. He doesn't have any restrictions regarding weekly holidays, and he doesn't have to notify the inspector. Or if the establishment is a government school or aided recognized school, if the adolescent is working in any government school or aided recognized school or any work provided by such organizations, then also these regulations does not apply to them. Next is section 10, disputes as to age. Sometimes it's difficult to identify the age of that particular individual. He might be a child, he might be adolescent, or he might also be an adult. So they need to have a medical certificate prescribed by medical certificate given by a prescribed medical authority. In case the medical certificate is absent, then the inspector will refer the case to the prescribed medical authority who will decide, and then the individual will be identified as a child, adolescent, or any adult. Next is section 11, maintenance of registers. Every occupier of an establishment must maintain a register with name and birth of the adolescent, hours and period of work, rest intervals, nature of work, and other prescribed particulars. And these registers should be made available to the inspector whenever he need. Next is section 12, display of notice. Every railway administration, port authority, occupier must display in English and the local language all the abstracts of section 3A and section 14. We have already seen the section 3A. We are going to see the next section 14 in the next some minutes. Next is section 13, health and safety rules. So appropriate government can also make some health and safety rules for the adolescent. The rules can cover issues related to cleanliness, freedom from nuisance, waste disposal, ventilation, dust and fumes, humidification, lighting, drinking water, spit-ons, fencing of machineries, walk near moving machinery, any kind of training or supervision on dangerous machines, power cut of devices, easing of new machinery, self-acting machines, pits, terms, floor opening, eye protection, means anything that is there in that particular establishment and which can impact the health and safety of adolescent, then the appropriate government can make rules regarding that particular things. Next is part 4, miscellaneous. That is section 14, penalties. We have already talked about that the notices regarding everything should be displayed by Railway Administration, Port Authority and Occupier in English and local language, especially the Section 3A provisions and Section 14 provisions. Section 3A talks about the adolescents working in establishment. Section 14 talks about the penalties in case of violation of any provision of this act. In case an occupier employs a child, then he can be imprisoned for 6 months to 2 years, or he can be fined from 20,000 to 50,000. But in case the employer or the occupier is some parent or guardian now, they should not be punished until they permit the working for commercial purposes. Assume any employer is employing a child. The employer should be punished, but a parent should not be punished until and unless they have permitted it for commercial purposes. So, if some parents might have permitted their child to go and earn money, then they should be punished. But if they are employing them in their own family enterprises, then they should not be punished. Next is for employing an adolescent, Section 3A violation. If someone is employing any adolescent in any hazardous processes, then they should be imprisoned for 6 months to 2 years, fine of 20,000 to 50,000. And in case of parents and guardian, they should not be punished until they permit the contravention of Section 3A, means they allow the individual to work in an establishment which is hazardous. Then there is first offense exception. Any parent or any guardian is not liable for the first offense. If they are committing the offense for the first time under Section 3 or 3A, then they should be allowed exceptions and they should not be punished. If employer repeat the offenses, but in case of first time, the employer is punished with 6 months to 2 years, 20,000 to 50,000 fine. But he does the offense again, then his imprisonment increases from 1 to 3 years. And if the parents and guardian are doing it, then they should be fined up to 10,000. So you have to understand two differences. If any individual other than a parents are doing, or other than a guardian is doing something with a child or adolescent in their employment, then they should be punished for the first time. But parents and guardian should not be punished for the first time. In case of second time, the employer will be punished with an imprisonment of 1 to 3 years. But the parents and guardian will only be punished with a fine up to 10,000. They won't get any imprisonment. If anyone is contravening any other rules or any other provisions, they should get up to 1 month of imprisonment or a fine up to 10,000 or the both. So you have to understand two things: the difference between ordinary employer and any parents and guardian, how they are treated and how penalties are imposed on them. In this act particular, penalties are important because there is differentiation between general individual and parents or guardian. Next is Section 14A, offenses to be cognizable. Any offenses by employer which is punishable under Section 3 or 3A is an cognizable offense. Only by the employer, not by the parents or guardian. If the offenses has been committed by an employer, then it is a cognizable offense under CRPC 1973. Next is Section 14B, Child and Adolescent Labor Rehabilitation Fund. Every appropriate government in each district or a group of districts in some cases will establish a Child and Adolescent Labor Rehabilitation Fund. The main purpose of this fund is to help the rescuing of child and adolescent and provide them with proper amenities when they are rescued from child or adolescent labor. What are the sources of this fund? Whatever the fines that are being realized from the employers under this act is deposited in that particular fund. Also, for every individual child or every adolescent rescued, government contribute a 15,000. So there are two sources. One is fine realized from employers. Second, government contribution of 15,000 for every child or adolescent rescued by the authorities. And the management of this fund is run by the government. The usage is whatever the principal plus the interest is paid to the rescued child or adolescent at the prescribed norm. Whatever the money is there in the fund now, whether it is fine plus the government contribution, the total of debt plus interest is provided to the rescued child or adolescent who can use it for his own welfare and betterment. Definition of appropriate government also includes any union territories administrator or lieutenant governor under Article 239A, that is for Delhi. Next is Section 14C, Rehabilitation of Rescued Child. The rehabilitation process work as per the laws in force. We have no specified procedure given in this particular act. Next is Section 14, Compounding of offences. So, the district magistrate have power to compound the offences if the offences are first-time offences under Section 14(3), or the offences are committed by the guardian or parents for the first time. Then the district magistrate can compound or settle these offences. What is the procedure for that? The offender applies to the district magistrate, pays the prescribed amount, then the district magistrate can settle the or compound the offences. If the amount is not paid, then the regular trial, whatever was going on, will continue. What is the effect of compounding? If the district magistrate has compounded the offences and the prosecution has not started, then no case is filed. If the prosecution is started, then that compounding of offences must be put before court, and if court also approves the compounding, then the accused are discharged from the offences. Next is Section 15, Modified Application of Certain Laws in Relation to Penalties. This is not important from exam perspective at all. It says that if convicted for contravention under below laws, penalty as per the Section 14 of this Act will apply, not under the respective laws. If that means if anyone contravenes Section 67 of Factories Act, Section 14 of Mine Act, Section 109 of Merchant Shipping Act, or Section 21 of Motor Transport Workers Act 1961, then these the penalties given under these following acts will not apply, but the penalty under Section 14 of child and adolescent labor will apply to these particular offences. Next is Section 16, procedures relating to offences. So this is important. If some offences has been committed, if someone has employed any child or someone has employed any adolescent in any hazardous process or occupation, then who is allowed to file complaint on their behalf? Any individual. That means there is no bar. Any individual, whether they have any locus standi or not, they are allowed to file. Any police officer or any inspector also can file complaint in a court of competent jurisdiction. Whatever court have the jurisdiction in that particular area, is allowed to take complaint from any individual, police officer or inspector regarding any offences committed under this act. And who can certify the age of individual? The certificate of age should be issued by a prescribed medical authority only, and that certificate alone, which is issued by a prescribed medical authority, is a conclusive evidence of age. That means any other certificate or any else document will not be permitted as an evidence of age for a child or adolescent. These all trials will not be tried before any court lesser than metropolitan magistrate or magistrate of first class. Next is Section 17, appointment of inspector. Appropriate government may appoint the inspector. As we have seen in all the other acts, we need an inspector to ensure the compliance of this act, and the inspectors are generally considered as a public servant under the IPC Section 21. Next is 17A, role of district magistrate. The government can confer power or impose duties on the district magistrate for the proper implementation of this act. Means, in order to implement this act, district magistrate can be given power and duties. District magistrate can also delegate these power and duty to subordinate officer and also can define their jurisdiction. Next is Section 17B, inspection and monitoring. Appropriate government must conduct proper inspections, periodic inspections, and ensure that the act is implemented in letter and spirit at the ground level. So we have already talked about the schedule multiple times. Schedule means these are the occupation and processes which are prohibited for adolescent. All the work is prohibited for children, but there are certain hazardous works and occupations which are prohibited for adolescent. If we talk about the occupations, for example, transport of passengers, goods, or mail by railways, anyone who is working on railway premises near tracks or moving trains. If someone is working at port selling firecrackers, working in slaughterhouse, automobile workshop and garages, foundries, handling toxic and flammable substances, or working in a handloom, working in mines, or working in plastic unit and fiberglass workshops, then these kinds of occupation and many more such occupations are prohibited for work for adolescents. If you talk about processes, if someone is involved in bead making, carpet weaving, cement manufacturing, cloth printing, dyeing, weaving, or manufacture of matches, explosive or fireworks, soap manufacture, tanning, wool cleaning, or working in some automobile repairs, maintenance, brick planes, roof tile units, lock making, paper making, and all those such units which are hazardous for the health and safety of that particular adolescent, they are prohibited for work of adolescents. So we have, with this act, we have completed what are the areas where child, or what are the areas where adolescent is allowed to work and where they are not allowed to work. With this, we end this particular act. We will meet in the next lecture.